This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law. Welcome to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Schnorman.
Welcome to Lawline. This year, New York City will pay out over $262 million in awards in personal injury cases. Mayor Giuliani and his corporation counsel, Paul Carratti, have proposed sweeping tort reform measures for all negligence cases brought against the City of New York. Today we'll look at the suggested changes as well as the effect of these changes on the court system itself. Our guests are Paul Carratti, corporation counsel for the City of New York, and Judge Douglas McKeon, Supreme Court Justice sitting in the Bronx County, who oversees over 7,500 city cases in his part. Hello, Paul. Hello, Judge McKeon.
Alan,
Nice to see you, Alan.
Paul, tell me, what is this crisis against the City of New York? Tell us about it.
Well, I wouldn't characterize it as a crisis, Alan. I think it's something that's been building for a very long period of time. Right now, the Law Department of the City of New York has over 135,000 cases pending against the city where we represent the city's interests. 70,000 of those are tort cases. And for too long, the city, I think, has been victimized by tort cases where plaintiffs have extravagant dreams of what they ought to be awarded in terms of compensation. It is a lottery ticket. The city is a deep pocket for too many different plaintiffs. And what we're trying to do in Albany through legislation is revise our tort system in the state of New York so that there are caps placed on pain and suffering recoveries against the City of New York. And we think that those limitations are fair and reasonable. They've been adopted by 39 other states, and we're asking New York State to take a look at it. So that is our legislative proposal. Within the city, we're trying to be more aggressive in terms of early investigation and early settlement and taking more aggressive posture with litigation in order to protect the city against liability. When you say $262 million, you have to realize that $262 million is more than the budget for the Parks Department. It's more than the budget for our cultural institutions. It's more than our budget for libraries. This $262 million has to be raised by the taxpayers, and the taxpayers, in effect, are subsidizing plaintiffs and plaintiffs' lawyers who bring these actions, many of them, I think, not well-based against the City of New York.
But of course, there must be some of those actions. You have victims of accidents due to the negligence of the City of New York, I'm sure.
Yes, and they should be compensated. But we have many more cases where the city has major exposure because the plaintiff couldn't find anybody else to sue. Let me give you an example. You'll have a person injured at an intersection, and because one car crossed and ran a red light. And then because that person doesn't have adequate insurance, you'll find that the city will be sued as well. And the allegation against the city will be, well, the traffic light wasn't properly placed, it wasn't properly timed, it should have been hung in a different way. And the plaintiff will introduce a scientist who will say, from a traffic standpoint, the city was negligent. And then the plaintiff is allowed to recover. Now, if the automobile insurance for the offending driver were adequate, the city wouldn't have been cast into liability. There's a continual reaching out to make the city a deep pocket and therefore responsible for these injuries.
Judge, what effect has all these cases had on the court system?
Well, it depends, Alan, the venue that you're speaking of. Where I am, about 1/4 of our civil caseload are cases involving the City of New York, the Health and Hospitals Corporation, Transit Authority, the types of cases that Paul's office would be involved with. That ranges anywhere from the trip and fall on a sidewalk to the brain-damaged baby who's born at a municipal hospital and is profoundly brain damaged and must be cared for the remainder of his or her life. We're seeing an interesting category of cases now coming to the fore involving lead paint poisoning in some of our poorer communities. Regrettably for the city, they've been involved in those cases because as part of their governmental function, they often have to take over the running of apartment dwellings under their in-rem program, and they step into the shoes of being the owner of those buildings.
You mean
So-
when you don't pay your taxes?
That's exactly right, where a landlord fails to pay taxes and the city is obligated to come in and take over those buildings. And in taking them over, they sometimes have to take over the headaches that go with them. One of them being the particular problem with lead paint, which is on the rise to a considerable amount, and often involving youngsters who are damaged for the rest of their life, intellectually and otherwise. So we're finding, certainly in the Bronx, that we're getting more and more cases brought against the city for some of the reasons that Paul has discussed, mainly that they are a deep pocket, but also because the city is obligated to perform roles in society that no other entity is. And with that goes a certain liability in the tort field.
Well, I think it's, if I could just elaborate on what the judge said, and certainly with regard to the city being forced to take over in-rem properties. You look at many housing advocates and they'll say the city should take over the property because the landlord, the existing landlord, has breached his obligations to the tenants, and he's breached his obligations. The city hasn't paid his taxes. So they encourage the city to take over the property so that the city will provide the basic essential services to the tenants. Otherwise, we'd be left in a terrible situation. So the city then comes in. The reward for the city coming in and taking over and assuming this obligation is that we get sued. And to Judge McKeon, if I could elaborate just a little point, we're sued not only because of our ownership interests, we're also sued as a regulator, where an existing landlord has not discharged his responsibility. They'll say, well, the landlord is the 123 XYZ Corporation, an asset which is certainly without any real value. And so they turn around and they sue the city, and they said, now the city, had you done your job adequately as a regulator, you would have found out about this lead paint, you would have prevented it, and this child wouldn't have had this injury, and therefore you're liable on that basis.
The curious thing, Alan, is that very often, as you know, when many of these children go to a hospital or a municipal hospital and lead is found in their system, the Department of Health is notified, which in turn cites its co-agency, the Department of Health Preservation, for the existence of lead in apartments. So it's actually the city citing itself in those particular cases.
Citing the city to go out and inspect and examine, and when there's a failure to do that and abate the condition, the city's held responsible. Also, you should know that with regard to these children, you'll have 5 or 6 children in a family, and you'll have all of them, unfortunately, with very low IQs. Only one of them will have an elevated lead level in its blood, and the city will be found liable, notwithstanding the history that the other family is, maybe because of whatever defects exist in the family. They're all similarly situated. One is not any smarter than the other. They're all equally impacted, but only one has lead paint, yet the city is still found liable for that.
Well, Paul, let me ask you this. You had said that one of the suggestions you gave to the state to implement is a cutoff of $250,000 for pain and suffering.
Yeah.
Would that also apply to a lead paint case where a child is severely
Well, no, because in those particular cases, we are asking, it doesn't have anything to do with economic damages. So if you have economic damages, in other words, you have to require extra care, extra comfort, institutional or custodial care, where there's a loss, where they project that a child of 5 or 6 could earn over its lifetime tens of thousands, hundreds of thousands, millions of dollars, you would be compensated for that. We're only asking for a cap on pain and suffering. Well, we find in our verdicts over $1 million that 90% of the amount in excess of $1 million is for pain and suffering.
Paul, I think Alan's question goes to the issue of loss of enjoyment in life, which our courts have said is part of pain and suffering. And very often in those cases that I presided over in the lead paint area, the major area of damage is the fact that the youngster cannot intellectually appreciate some of the things that you and I, thank God, can. Not only are they not able to work, they're not able to enjoy sufficiently the beauty and the things that intellect provide us with. And I assume, Alan, that what you're driving at is, by capping that kind of damage, perhaps we're putting an unfairly low number on that item of damage.
Well, I'd have to disagree with you, because that was my point before. In a large family where you have 3 or 4 or 5 children, only one will have elevated lead blood levels, and yet all of them will have the same intellectual impairment. So it's very difficult to make the argument that because of the lead paint, the elevated lead levels, that one person is less capable of enjoying when they're all suffering from the same deficiencies.
That's usually something that is tried during the course of the case. In other words, the defense to these cases, as you know, Alan, is, well, Perhaps the youngster had lead in his or her system, but the fact that they have a low IQ is because that's the way the Almighty made them. And that's evidenced by the fact that brother and sister also have low IQs, and mom and dad likewise. Now, implicit in a jury's award is a rejection of that. I happen to think wrongly so, Paul, on some occasions.
Well,
but
the juries in your particular county, Judge, are uncommonly generous with regard to awarding...
it's a philosophical issue as well,
yes,
up in the
sure
Bronx
is.
and in Brooklyn.
Well, let me ask you this. I'm getting the impression from you that you feel the court system is not doing its proper job, that it's running almost amok, and you're getting hit, and you should not be getting held to be so responsible for such a high level.
Yeah, that's well stated. And I'll tell you why we feel this way. Because when I go up as a corporation counsel, and I talk to the Corporation Council of Buffalo, in Rochester, in Syracuse, and Albany, all of which have the same problems that all those cities have, essentially the same problems that we have here in the city of New York, not in the vastness, not in the array, not in the number, but essentially the same problems. There's lead paint in Buffalo, there's lead paint in Rochester, and so forth, and yet they don't have the exposure. And I'll tell you why. Because those are home ownership communities. And in those home ownership communities, those taxpayers say, well, we're not going to do this. So when we try to go up to Buffalo and Rochester to get support for our tort reform proposals, they say, we agree with you, but it's not an issue here. And I'll tell you something else, Alan, which most people don't recognize, is this is not as great a problem in Queens and in Brooklyn as it is in the Bronx and Manhattan.
Well, Judge McKeon is
Bronx and Brooklyn.
How do you answer that?
Well, from the city's point of view, it is a problem in the Bronx because let's face it, Alan, and you're aware of it, jurors from poorer communities have a tendency in these kinds of cases to be far more generous than their prosperous counterparts in some of the other boroughs. Now, having said that, however, we do have appellate courts in this state, and particularly the appellate court that presides over the Bronx and Manhattan has, I must say, also indicated a rather generous point of view toward many of these awards. And if a judge is to perform his or her function in accordance with prevailing pronouncements in these areas in Bronx County, we know that our appellate courts have told us what these cases are worth. I must say I think that Paul is right that the judiciary has not been as courageous in many instances as they should be, and there are times when a judge should have the courage to dismiss a case when it takes courage to do so. We have yet to see in Bronx County, since I presided over the city part, and that's for at least 5 years now, one verdict in favor of a hospital in a brain-damaged baby case. Nor am I aware of any judge who set aside one of those verdicts. Why do I raise that particular type of case? Because very often what you have in the courtroom is a profoundly brain-damaged child who makes your heart cry to see the state that they're in. And that's obviously a very, very difficult situation for jurors to deal with. And certainly I can say in my own instance, it's a profoundly difficult situation to deal with. However, we do know that not every child is born into this world in that state because of the negligence of a doctor. And what I'm suggesting is that in certain venues, certain kinds of cases have literally become indefensible from the point of view of the city and the Health and Hospitals
But
Corporation.
of course, a verdict comes in, the judge can set this verdict aside, the judge can dismiss the case, the judge can lower the verdict.
Yes.
And then, even
And
after that...
all too often, though, Alan, they don't. And
And-
I'm saying to you, in other jurisdictions in the state of New York, they frequently exercise those powers, and they're backed up by their local appellate division. That's true in the 2nd, 3rd, and 4th departments. It's not true in the Bronx and Manhattan. And
You're
it's not
saying
true
the
in-
appellate division in the 1st department does not?
No,
In
they
your
don't.
opinion?
In my opinion, and if you look at the 2nd department as opposed to the 1st department, you'll see the 2nd department exercising its prerogatives
And the
far more
2nd
closely.
department is Brooklyn, Queens, and
Staten Island.
and Nassau and
Westchester.
Suffolk, and some counties upstate. We
Westchester
have to go to a
and
break
Putnam
now. We'll be right back. We'll find out what happens in your most commonly cases that are sued against the city. You'll find out how to sue the city. Stay tuned. You're watching Lawline. I'm Alan Schnorman, your host. Hello, I'm Alan Schnorman. Most of you know me as the host of Lawline, where I interview the most knowledgeable attorneys in the field of law today. So I understand the importance of choosing the right attorney to represent you. With so many law firms to choose from in personal injury law, how do you know who to call? At my firm, Zalman & Schnorman, we fight for the rights of accident victims. If you have been hurt in an accident of any kind, including construction accidents, you may be entitled to a substantial money award for your pain and suffering. Don't try to evaluate your case yourself. Call us at 1-800-LAW-LINE for a free consultation. If you are too injured to come to our office, we will come to you. We get paid only when your case is settled or won. If you have any questions about your accident, call us at 1-800-LAW-LINE. Remember, the insurance companies have lawyers representing them, and so should you. Hello, you're watching Lawline. I'm Alan Schnorman, your host. Today we're talking about the high cost of negligence cases against the City of New York. Our guests are Paul Karate, Corporation Counsel for the City, and Judge Douglas McKeon, Supreme Court Justice sitting in the Bronx County. Paul, I was asking you right before the break, tell us, what are the common cases against the city?
Well, the most common case against the city, Alan, deal with slips and falls on the sidewalks.
All right, who owns the sidewalks?
Well, the sidewalks are owned by the abutting property owner, but the abutting property owner is not responsible for the
But that's the guy who lives next door to the sidewalk.
That's right. The city is held responsible for it. And the city is, about 4,000 or 5,000 cases every single year are brought against the city because people claim to have slipped and fallen on a sidewalk.
If I'm walking down Madison Avenue, and let's assume there's a 3-inch difference in the height of one pavement to the other, and I trip over it, I can sue the city.
Provided that the city is on notice that that is an alleged defect, and the city has to have prior notice of that. There's a group put together by the Trial Lawyers Association called the Big Apple Mapping Association, which periodically files with the City of New York maps showing defects on sidewalks and streets, and that's deemed to constitute notice to the city of the defect. But essentially, yes, if there's a defect in the sidewalk and somebody slips and falls on that sidewalk, they can bring an action against the city, and they do.
And the city is the one who's responsible for that sidewalk being not leveled, not the abutting property owner, not the guy whose house it's in front of.
This is a serious anomaly and in the law, and we've gone to the legislature to ask them to transfer responsibility to the abutting owner. Now, this is one area where we think we made progress with the Trial Lawyers Association because they agreed with us. The problem is the insurance industry and the real estate industry have disagreed. So while we get the bill passed in the Assembly, we could never get it passed in the Senate.
Judge, I'm walking down the street and there's snow and ice on the sidewalk, and I fall and I break my arm. Who can I sue?
Well, you can always sue the city. Now, that's a more difficult case, Alan. There's been case law, and the courts have spoken to the fact that the city has anywhere from 2 days or beyond that to rid the sidewalk of that snow and ice condition. So it's a different ballgame than the situation where you fall on a defect on the sidewalk. But what I wanted to get into with you before, Alan, and I neglected to, we're seeing an enormous increase in the amount of police brutality cases in the aftermath of the Rodney King incident of several years ago. We're seeing it in Bronx County.
Yes, of course.
And I suspect in Brooklyn as well, Paul. And these cases are very, very difficult and have resulted in some instances in enormous verdicts and settlements.
But they are difficult cases. We're asking our police department now, 38,000 strong, to be more aggressive and assertive in ferreting out crime. And so there's more interaction between the police and the population of the city of New York. Arrests are an all-time high. I'm not sure that the incidents, the ratio of arrests to incidents resulting in lawsuits is on the increase, but I can tell you there's one heck of a lot more arrests, and that's why the crime rate is down. But it has resulted in more allegations of police brutality, both in the state court system and also in the federal system. We find that many practitioners prefer to bring these lawsuits not in a tort action in state court, but in a civil rights action in federal court. And so we're seeing a rise both in these actions, both in our state system and in the federal system as well.
Well, how do you feel about that? You're a corporation counsel, but you're also an individual. You're also a citizen. If your home was, for instance, all of a sudden some police officers came to your house and on an anonymous tip and searched your premises for narcotics and it was a mistake.
Yeah. Well, I don't think they can do that without a warrant. But assuming
and
they
what
did
if they did it without a
well,
warrant? What happens?
I think
Would that be,
I think the police have an extraordinarily difficult situation because most of these incidents don't occur from situations like the one you describe, Alan, but from somebody making an arrest or somebody exercising force. Now,
undue harsh force?
Undue harsh force. But the policeman, you see, is confronted with a very, very difficult situation where he has to make an instantaneous decision, and he's afraid that something may happen. He may be assaulted, he may be shot, because police officers are shot all the time, and so he has to make a decision. So he makes a decision. It's a fast decision. It's made almost by instinct, and we try to train our police officers to exercise their instincts in a particular direction. Now, on the other hand, then the lawsuit starts. Well, then there's depositions, then there's analysis, then there's people, making things up or conjuring up images. And so you have this incident, which probably took maybe 2 minutes to occur, is replayed in slow motion before a jury. 5, 10, 15 days of trial to demonstrate what took place in the arrest and how the person feels about it. And yes, the jury gets a very erroneous impression of what actually took place. And unfortunately, sometimes the city is cast into liability when it shouldn't be.
Of course, Paul,
on the other hand, we do make mistakes, and we pay for those mistakes.
Yes, but I must say that with the O.J. Simpson trial, with Furman, that sort of thing, we are seeing these cases along racial lines. And that's what I find to be sad as a citizen and disturbing also. There seems to be now cases that where perhaps an officer acted in good faith in the criminal sense, now finding their way into the civil side of the court and really starting to break along racial lines such that, again, it seems as if various communities are pitted against one another. We often find the white Caucasian police officer accused of brutality against a Hispanic or a black defendant with the kind of racial overtones that really are quite disturbing.
Well, I wouldn't say it's in the black community only, because you'll have an awful lot of white civilians who are arrested by black or Hispanic officers who say, hey, well, you're treating me this way because I happen to be white,
of course,
and you're trying to even the score of a lot of other things.
All you have to do is read the Mullen Commission's report to know that this occurs, it happens.
Yes, but does it occur, Alan, in the kinds of numbers and in the volume that these lawsuits suggest?
Alan, listen, we have 38,000 policemen. 22,000 we try to keep on the street all the time.
Right.
They're making hundreds of thousands of arrests every single year. When you look at these number of lawsuits, and while they're going up, I mean, it's a tiny percentage of the arrests that are made. And I'm telling you, more frequently than not, indeed the overwhelming majority of these arrests are good and don't result in any lawsuits. And even the lawsuits, many of them are spurious. Those that are not spurious, we have to try and or settle. But we get rid of an awful lot of these cases too.
Let me ask you, sir, what is the settlement process? Do you, if I have a claim against the city of New York, and it's a legitimate claim, there's no question. This claim, you say this is a legitimate claim. Do I get a call? Do you settle it right away?
Yeah, well, we try to work on that very strenuously because if somebody has been injured and the city is at fault, then it doesn't do the city any good to delay the day when we have to pay money.
Right.
And we're trying to experiment now with Judge McKeon and judges in Manhattan and in Brooklyn and with the Office of Court Administration on some of these cases where the city clearly has an exposure to cover that exposure at the earliest possible time. The process is simple. You file your action. Many of these cases are referred to our early investigation unit. They're summoned up for a conference before the judges. Judge McKeon is one in the Bronx. We try to put a value on the case. We ask that the plaintiff put a fair value on the case. The city cannot settle, the law department cannot settle lawsuits by itself. We need the controller to participate, who sends a separate independent representative.
It depends, Helen, on what your definition is of a legitimate claim. And I don't say that tongue-in-cheek.
I understand.
Is a legitimate claim one in which a person claims to fall on a sidewalk, and when you look at the emergency room record, says that they fell at home?
I'm crossing at an intersection. A garbage truck makes a left-hand turn. We both have the light. I have the right-of-way, and he strikes me down in the intersection. That's an easy one.
That's an easy one. But how badly were you injured, and how much money do you want? Did you sprain your ankle? Did you fracture your skull?
How do you know what a case is worth? How do you know how much money to offer on a case?
Well,
before the jury is going to give millions?
Well, I think we know that based on experience. We know that a leg being broken in the Bronx is $25,000 or is $50,000 or is $15,000. We know that based on experience, and there's shifts. Now, we have to also weigh in what your economic circumstances are. If you're Donald Trump, your leg, unfortunately, is worth more than my leg is
a
worth,
working person.
because he has a higher earning, and he's
Paul,
adversely impacted.
and it depends if somebody is represented by someone of the stature of an Alan Schnerman, and I don't say that merely to cajole you, Alan.
That's true. Plaintiffs are better those that are better represented stand a better chance of getting a higher recovery sooner.
We know that we can settle certain cases with certain lawyers for a lot less for the same injury than we can with others. This is something that comes over experience in dealing with as many cases as certainly I do and have over the last 5 years in presiding over all of the city cases in the Bronx. And we've settled cases from 500 up to multiple millions. So, I mean, it's a very interesting skill that goes into it. But
How long does it take? I fell down on the sidewalk. I've commenced an action. Till I get to trial, how long does that take against the city of New York?
Well, it's interesting that you raised the fall on the sidewalk case, because I have to say that Paul has been just outstanding in trying to work with us in treating that type of a case in a special way. In other words, I happen to feel that a case where somebody sprains an ankle or breaks an ankle on a sidewalk ought to be treated differently than the case where a youngster is profoundly brain damaged for life.
Okay.
In other words, if one case requires an extensive discovery and extensive discussion to ultimately resolve it, it ought to be treated in one category. These cases where we know we can dispose of them quite readily, if we deal with them in a specialized way, ought to be treated in another.
How long? How long does it take?
Well, it all depends.
Years now.
How, is it 2 years?
It takes too
Beyond
long.
that.
3 years?
It takes 3 or 4 years. It takes
Absolutely.
4 years from the...
It takes far too long, Ellen, and believe me.
Does the person get interest on that money until he gets it?
No, they do not.
So is it in the interest of the city to delay these cases?
Well, no, I mean, and that's an unfair charge. What we're trying to do now...
I didn't say it was a charge.
What we're trying to
Well,
do,
some have
Alan...
made it.
Some people have made it. I'm sure you haven't. But what we try to do now is put a value on these cases sooner. Because with 70,000 cases, those cases where we're going to pay eventually, we might as well pay right away so we can devote our time and attention to the cases where there really is a serious question as to liability.
Let me ask you this, Paul, if I may. You have, let's assume, a known defect. Let's assume it's in a roadway, and you know there's a defect, and you get a claim in, and it comes into your office, and it's a serious injury. Do you then send out a notice to whoever repairs that pothole or roadway which is in poor condition or constructed to repair it?
Well, we work very closely with the Department of Transportation.
You do.
We're trying to increase our liaison all the time. As a matter of fact, we have a new commissioner who's trying to work at where the potholes are, where we always have to do these remedial fill-ins, to do it earlier.
To correct it so another accident doesn't happen.
To correct it earlier.
Quickly, would you like to say in summation, Judge?
Well, I think that the trip and fall case is one category of case. Now, you say about early settlement, and you suggest, Alan, that the city is intentionally holding back. It's a two-way street. Plaintiffs' lawyers as well are asked for enormous amounts of money early on that make these cases very often unsettlable.
Judge Douglas McKeon, Supreme Court, Bronx County, thank you very much for appearing on Law Line. Paul Karate, Corporation Counsel for the City of New York. Certainly with 600 lawyers under your belt, a tough job. Thank you for appearing on Law Line.
Alan, thank you.
And as always, this is Alan Schnorman. Thank you for watching Law Line.
You have been watching Law Line with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Law Line, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.